So $50 and a 12-pack of beer. So $50 and 12-pack of beer was what was taken from the Bay Harbor pool room in Panama City, Florida on June 3rd, 1961. $50 and a 12-pack of beer is what landed Clarence Earl Gideon in jail. That's what led to his conviction. That's what led to his 5-year sentence in a Florida prison. Before he was convicted, Clarence Earl Gideon told the judge that he couldn't afford counsel and that he wanted the court to appoint an attorney to him. But the court refused. Florida courts at the time could only appoint counsel in a death penalty case. So Mr. Gideon went to trial by himself, no attorney by his side, and he was convicted. And he sat in a Florida prison, and he sat in a Florida prison, and he sat in a Florida prison. And as he was sitting there, he wrote this petition to the United States Supreme Court, asking the court to take his case. The court agreed. They agreed to hear his case against the odds. And when he went up, the court actually appointed one of the best U.S. Supreme Court litigators in the country, Abe Fortas, a future Supreme Court justice. Abe Fortas went to the U.S. Supreme Court and he argued that no person should stand against the power of the state without an attorney by their side. So the U.S. Supreme Court came back on March 18th, 1963, and here's what they wrote. Lawyers in criminal courts are necessities, not luxuries. The right to counsel, the court said, may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. Gideon versus Wainwright represented a sea change in American criminal jurisprudence. After Gideon, the states, all 50 states, were required to provide an attorney to people who couldn't afford one in a criminal case. Tomorrow, March 18th, marks the 60th anniversary of Gideon versus Wainwright. The 60th anniversary is a good time to take stock. Where have we succeeded in Texas? Where have we failed? How would Mr. Gideon fare if he were arrested in Texas today? Texas is a fascinating place for public defense, by the way. It really is. In many ways, we've been innovators. If you look back to the 1800s, Texas founders like David Burnett and Thomas Jefferson Rusk represented poor criminal defendants. In the 1800s, Texas founders represented criminal defendants in what we'd call public defense today. In 1914, nearly 50 years before Gideon, Texas became one of the first states to create a public defender office. In 2001, thanks to one of our speakers, the Texas legislature created the Texas Fair Defense Act, creating structure and funding for Texas public defense. And even today, Texas is building public defender offices at a faster clip than any other state in the nation. But we've also fallen short. Last week, the Sixth Amendment Center released a study showing that Texas is 46th in the nation when it comes to public defense funding, 46th. In fact, Texas spends just 50% of the national average per capita on public defense, so only half of the national average. While most states fund public defense at the state level at 100%, the state of Texas only funds 17%, leaving the counties to pay for the other 83%. And attorney appointment rates in some Texas counties fall woefully short of state and national averages. So we've got our problems. Today, you're going to hear from some of the best minds in public defense in Texas and across America. You'll hear from former Texas State Senator Rodney Ellis, who created the Texas Fair Defense Act. You'll hear from lawyers and judges from rural Texas who will tell you the good, the bad, and the ugly of rural defense. You're going to hear from Mr. Anthony Graves. Mr. Anthony Graves leads the peer navigation program for the Harris County Public Defender Office, but before that, Mr. Graves was incarcerated for over 18 years in Texas prisons, including 12 years on death row before he was exonerated. You also hear from public defense innovators from across Texas about how technology, holistic defense, regional programs are changing the way that we actually provide public defense in Texas. So we have a good lineup for you today. We're grateful to Representative Reggie Smith, who let us use the Capitol Auditorium, his sponsorship. We're very grateful to him. We're grateful to the Texas Tribune. We're so excited that you all jumped at the opportunity to stream this event and to help moderate. We're grateful to you all who are here with us at the Capitol to join us to celebrate Gideon Day. And we're grateful for the folks, the hundreds of folks at home who are watching this remotely and care about Gideon versus Wainwright. And in Mr. Gideon's case, after he won in the U.S. Supreme Court, he wasn't released, at least not immediately. Mr. Gideon's case went all the way back down to Florida, and this time he was retried with an attorney by his side. There was an attorney named Fred Turner who represented him, a local attorney in Panama City. Mr. Turner learned that Mr. Gideon's conviction turned on the conviction of, or the testimony of just one man, a 20-year-old named Henry Cook. Now, Henry, according to his testimony, had been at a dance hall 60 miles away and had just been dropped off outside the pool hall by some friends at 5:30 in the morning, just at the time that he says he saw Mr. Gideon inside the pool hall, supposedly taking that 12-pack of beer and the $50. Well, Mr. Turner did something Mr. Gideon couldn't do. He went back to the scene of the crime. And what he saw there was a pool hall with large windows. And the windows were filled, top to bottom, with advertisements. No one from the street could have seen into that pool hall. With that evidence, a jury found Mr. Gideon not guilty. So thank you very much for being here today. And it's my pleasure to introduce Commissioner Rodney Ellis and the editor-in-chief of the Texas Tribune, Sul Chan. Thank you.
Good morning, everyone. How are you all doing this Friday, St. Patrick's Day? Great to see you. I'm Sul Chan. I'm the editor-in-chief of the Texas Tribune. We're the largest provider of nonprofit, nonpartisan news about the state government, politics, and public policies of the state of Texas. I am delighted and honored to be joined here today by Harris County Commissioner Rodney Ellis. Mr. Ellis needs no introduction, but I will try to offer one anyway. Rodney Ellis's distinguished career in public service includes nearly 6 years on the Houston City Council, nearly 27 years in the Texas State Senate, and since 2017, you, of course, have been serving on the Harris County Board of Commissioners. To read about Mr. Ellis's contributions to a more fair criminal justice system is really astonishing. Mr. Commissioner Ellis, you not only authored the Fair Justice Act mentioned earlier, which provided structure and funding for indigent defense, but you also worked on issues such as reviews of exoneration cases to understand what went wrong. You worked on setting up a statewide agency to represent indigent defendants in capital cases. And you also worked on laws that would provide compensation to those like Anthony Graves who were wrongly imprisoned. What inspired your interest in criminal justice?
Chen, thank you for doing this. It is so important that the Tribune would carry this live. And I do want to say to Jeff Burkhart, thank you for your life's work. They give credit to Confucius for this saying I love. If you find a job that you like, you'll never work a day in your life. And we're fortunate. I want to give you and your team a round of applause for what you do. So to answer your question, I was arrested in junior high school. That gives you a sense of how old I am. They call it middle school now. I was born in 1954, so I was 8 years old when this historic decision came down. And obviously it was a time of tremendous racial segregation in public schools in Houston and throughout the country, obviously then. And some kids were tearing up the bus. So the bus driver pulled over and called the police. They didn't have cell phones, you young people. So he went to something called a telephone booth. You never heard of that. He called the police. So I thought, I'm sitting there, didn't have an afro, my student council badge. I'm thinking, I'm fine. Student council badge would protect me. He picked about 4 black boys on the bus. I don't remember two of them, but one I remember because the judge said, it's a sad, I think his name was Sadberry. And the cop said, it's a sad day for you, Mr. Sadberry, because your black A is going to jail. So we go to jail. Can you imagine in the 7th, 8th grade? And when my parents came to get us, went to dinner table, and my daddy said, look, Rodney, if you did this, we're going to let the judge get you a jackleg. I didn't know what a jackleg lawyer was. But he said, we're going to let the judge get you a jackleg lawyer. But if you didn't do it, we'll hawk this house and get you a real lawyer so that you don't ruin your life. And I didn't do it, and I said I didn't do it. I do think my sister said something like, thinking about us getting out of that house. He did it. I love her, but she was not on the bus. But, you know, I always remember that. And when the opportunity came my way, by accident, kind of like Gideon, when I came to the legislature, the Senate in 1990, I was lucky. A series of political maneuvers. It was an uncontested race. And backroom politics, kind of, you know, I think you were in New York a while. You kind of know how that works, right? But I told my staff when I got here to the Capitol, I said, people elected me because I had an agenda. Truth of the matter is I didn't have a race. I didn't have one. You get me a damn agenda real quick so I can put these bills in. So I put in everything my predecessor, then Congressman Craig Washington, had. I looked for stuff other people had put in that didn't pass, not knowing you don't just steal some people's bills. You know, these are just bills. You go to Governing Magazine. But there was a young guy I mentioned you earlier, Mark Strama, young, kind of like intern at my staff. His sister was working for the public defender office in Maryland. And he mentioned, you know, I'm a lawyer, but he mentioned, you know, you ought to put in a bill to do a public defender's office. Good. That was 1991. So it was not until 1999 a version of it passed because the press had whipped up so much. So it was by accident. So I didn't really think the issue would define me, but it did for a good bit of my career here.
Commissioner, at age 68, you have lived through the war on poverty. The war, all of these are so-called. The war on poverty, the war on crime, the war on drugs. You've also witnessed, as a public official, the tendency toward mass incarceration. And then, of course, more recently, in the past couple of decades, a real awareness of, you know, Sixth Amendment rights and how they can be violated. We've had so many examples now of people who were wrongfully convicted, and there is so much more awareness now, I hope, of the racial disparities in the criminal justice system. How hopeful are you that society can find this balance between wanting public safety, but also making sure that our criminal justice procedures and the resources to protect those who are accused, that both are held, you know, kind of with equal strength and validity?
It's a great question, and it's scary. As Burkhardt said, we've made progress in Texas, but to be honest with you, not nearly enough. Most people are genuinely for reform before they are against it. You think about the history of our country. You know, most people were against slavery. But the problem was, well, who's going to do the work? You got me? If you'd had to have a popular vote on it, even when Lincoln was in, I'm not sure if there'd been a vote on it, it would have passed. In Texas, we have, to a great extent, ignored the mandate of Gideon versus Wainwright. It said the state shall provide counsel. In Texas, what the state did was push it to the counties. Arguably, counties are a division of the state. Even in the bill that I passed in 91, the bill I passed in 99 did considerably more. You all did a analysis of the bill. Young reporter who did it dug up stuff I'd forgotten. You know, the memory fades after a while. The most significant thing in that first bill in 99 that Governor Bush vetoed was it forced every county to vote on its indigent defense system. And I was told by rural a legal aid.
Not even to approve it, but to have a vote.
Have a vote because this rural legal aid lawyer, whose name will come to me later, still around. He's in Santa Fe now, New Mexico. I call him every once in a while. But he said to me, if every county has the vote, I think we could sue someone to challenge the system. So I had to sue the judges. So really, I was compromising. That's probably how that bill in '99 passed, maybe unanimously out of the Senate, pretty close. But in a bill, and it did a lot more significant things than this one did, but it was vetoed. In this bill in 2001, the way I funded it, I was finance chair at the time. So by having a pen in my hand, I could be a little creative. I'm a banker, although I have a law degree. I was an investment banker. So what I did was sweep a fund. That means there was a local, fairly regressive court fee that was used to collect money, and it would sit in this account as a method of finance just to let us pass the budget. We never touch it. State hadn't touched it for years. It's just sitting there dormant, but you could use it to get the budget certified. So I decided the state had spent money on the top priorities that the lieutenant governor and I could get and find consensus with the Senate. So I didn't have any more money. So what I did was take that revenue, that fee, sweep that fund, and use that for the state putting money in indigent defense. Most of that money, Burkhart's coming from Harris County, from a court fee. But look, prior to that, the state hadn't put a dime in. We left it to the counties. But so that, look, there's progress, and he gave the figures. We've come a long way. Most of the counties have some capital system now. Most cases are not capital cases. Far too, even in my county, it was almost 9 years later in Harris County, which is the death penalty capital of the world, when it set up its public defender's office. When I became a county commissioner, it was handling 60% of the cases. We're 20% now. Most of the system is that old school, fairly sleazy, might I say, system of the judge picking a lawyer for someone accused of a crime. Inherent conflict of interest that violates the ABA principles. ABA ought to wake up. If you practice law without a license, that violates the rule, not the principle. You got me? You're in serious trouble for that, but it just violates the principle. We violate the principle in most counties in Texas, even the ones that have a PD office, because the vast majority of the cases, you still have the lawyer handling your case, picking the lawyer to represent you.
The judge picking.
The judge, which means that lawyer, if you're reasonable, you probably feel somewhat beholden. You're not going to walk in there like at my age, they had to show Perry Mason, and Miss Delia Reese would pass old Perry a note. Object? You nuts? Are you on something? You drinking Bud Light? You objecting to the judge that appointed you, his ruling or her ruling?
So you're saying that the most fierce advocates, for example, might not be as likely to get these cases assigned to them as, lawyers who
in most cases,
get
not
along a
all.
little bit more.
If you are Craig Washington,
Yeah.
If you have something that gives a state rep, state senator, but if you want another case, Harris County, we have lawyers. One lawyer made over $1 million last year on court-appointed cases, and that was only a percentage of their practice. Under the Fair Defense Act and additions to it, you do now have a will. County judge from Victoria County was mentioning the will to me this morning. I'm the guy that created the will. It's the best I could get. Legislation here is the art of asking for what you want, taking what you could get. So the will is in some ways a farce because all the judge has to do is cite a reason, like I didn't think they were qualified, and go to the next lawyer on the will. But we do have time limits. We have recommended caseload standards. There are a host of things in that 2001 bill. Additions have been made, but it was the best that I could do.
Commissioner Ellis, so basically we went from a system where none of the costs of public defense were borne by the state to the current status quo where 17% of the costs are borne by the state, 83% by the counties. As you say, Gideon v. Wainwright gives the states the obligation to fund this. In your view, is the problem with Gideon that it doesn't have an enforcement mechanism? Should there be a US DOJ or other method of actually making real the promises of Gideon?
There should be. And the big challenge is how do you force it? So if there were a way to get it into court, again, it would help. it's hard to expect county commissioners to get reelected on the issue of we put more money into indigent defense. Most people say they're for it, but until they face that system, they don't think about it. So look, there's room for tremendous improvement. In other parts of the country, sometimes when I have spoken, I chaired the Board of Innocence Project out of New York, in part because of this act. Barry Scheck and Peter Newfield asked me to go on their board, and I chaired it for 14 years. I'm no longer on the board now, but when I move around the country, a lot of times people would tell me, instead of pushing so hard for public defender offices, I should push for adequate funding. And I would say, well, hell, we just want one. First create it, and by having an office, then you create a advocacy entity within itself in Bexar County, Harris County, Fort Bend County. So you have experts who focus on it, not just leaving to the whim of politics. The state now does put some general revenue in it. Initially, in the bill I passed in 2001, there was no general revenue in it. That came later. Maybe a little, Jeff, before I left the Senate. We may have gotten a little in, I can't remember, very little. And it's gotten better, but it's still not nearly enough.
You mentioned the Innocence Project. We've had famous or notorious cases in America, such as the Central Park Five, such as the case of Mr. Anthony Graves, in which we had very high-profile convictions, and the people who went away to prison turned out to have been actually innocent, and they were wrongly accused. Has the wave of exonerations that we've witnessed over the past 2 decades or so, has that moved public opinion?
Exonerations have moved public opinion tremendously. In 2001 in Texas, in addition to the Fair Defense Act, we had bipartisan support to pass our DNA testing statute in Texas. Senator Robert Duncan was the lead sponsor. I was co-sponsor. Young person on my staff, Hannah Lieberman, who's now Dershowitz of that family. She married into Alan Dershowitz's family, did the work on it. When I got the finance chair, I needed to go work on the budget. So Duncan didn't change a word, but he was lead. We passed a bill to create the gold standard for compensation for people who were wrongfully convicted. I passed another one. I think it was vetoed. I think we passed a bill banning executing people who were mentally retarded. Term may not be politically correct, but in the statute, you have to say MR because that bill got vetoed by Governor Perry. But that in part prompted Barry Scheck and Peter to ask me to go on that board, and I chaired it. I would take being a lawyer, but a policy lawyer, not one who's in the details of criminal law. I'd have enough sense not to hire myself to be my lawyer. But I do have a pretty good policy mind. I would take every exoneration. Anthony Graves, as an example. We passed a bill. We should have put his name on. Texas until New York recently amended their law. Texas had the strongest discovery statute in America, the Michael Morton Act, over an exoneree, might I add, who fit the profile. He's Republican. He's white. He's about my age. He spent some almost 3 decades in jail for being convicted of killing his wife in front of his child, and it was a mistake. Many of those cases, by the way, early on in their lives, someone probably got convicted for something, a lesser offense, with a court-appointed lawyer. I can't remember if Anthony Graves had a court-appointed lawyer. On the death penalty case, he wouldn't have, but early on, he might have. Anthony Robinson, another famous exoneree, who's in Houston, the first one to get a law degree in America. I think we now have about 4 who've gone on to get law degrees, but he had a court-appointed lawyer initially. But yeah, the exonerations have moved the needle where it's irrefutable evidence. Even the shrewdest skeptic on the planet find it difficult to argue with DNA testing. We've had our issues. We had to deal with issues with our forensic science commission on the state level. That's a separate issue, if I can remember all of the names. But the prosecutor involved in Michael Morton's case, in part, I can't think of his name now, came out of that issue where we had problems getting the DNA testing. But yeah, exonerations have moved the needle in my judgment more than anything I can think of. But as I used to point out as chair of the Board of Innocence Project, most people who are in jail who are wrongfully convicted probably don't have DNA testing. You got me? DNA testing is a small sliver of the cases. I also point out on this issue of indigent defense, most people who are in jail probably are guilty, but some people are in jail because their lawyers ought to be in jail instead of them. A powerful statement I know, and one that I feel very strongly about. You know, people go to law school, that old joke, I hope they still don't have it. Any person can convict a guilty person. A really good lawyer could convict an innocent one. I don't know if they still say that, but that was the running joke in law school to just kind of make the point. If you really learn, hone the skill, and you're really good, you know, not so much the issue of getting to truth, where both sides argue, but anyway.
Well, now the prosecutor who put Anthony Graves in prison for 18 years, 12 of them on death row, was subsequently disbarred.
Yes.
Are there adequate kind of procedures and penalties to try to make sure that prosecutors are held accountable for prosecuting things honestly and following all the rules of evidence, which of course the prosecutor in the Graves case did not?
No. Clearly, the role of a local prosecutor is one of the most powerful and independent positions in this country. Tremendous power with very few checks and balances. The first prosecutor in the history of America to go to jail for wrongfully convicting someone was in the Michael Morton case. And he may have gotten, what was that name again? Ken Anderson. And he got a 30-day sentence, which he could do on the weekends. He might have spent 3 weekends in jail. 5 days. There you are. Good to see you. He spent 5 days in jail. But that's the first time. There may be others, but that's the first one in the history of America. Sebastian, was that his name from Anthony's case? Got disbarred. But no, there are very few checks and balances there. And that's a separate issue. And look, by the way, in no way to demean the role of a prosecutor or law enforcement. It's very difficult to find the person who killed someone. And there's tremendous pressure on law enforcement and the prosecutor to solve the case. Not tremendous pressure to get to the truth.
Well, we get back to that issue of the balance between public safety, but also the safeguards to make sure that investigations and prosecutions result in the correct outcome, not just an outcome that would satisfy the public. Commissioner Ellis, over the last 2 or 3 years, we have seen an increase in violent crime in a number of American cities in particular. Has that increase, and America, it seems, goes through waves, right, of kind of punition and reform. Are you fearful that we're in another entering or about to be in another wave of kind of so-called tough on crime policies that might result in, innocent people being put away?
We are in another wave, and the media, with all due respect, bears some of the responsibility. Blood sells. At the end of the day, I believe in capitalism. Downside of it is that sometimes the focus is more on revenue than reality. I've seen studies that show local television in particular, ratings go up, sales go up. The public always has an appetite for that. I don't blame President Bush and and his campaign consultants as much for, that ad out of Massachusetts, Willie Horton, the Willie Horton ad. I fault in many ways us, the public and the media, for being so gullible. Yeah, look, after George Floyd, those were the largest demonstrations in the history of the world against racial inequities. Largest, bigger than King's movement. And I can't help but think that in many ways it was a reaction. Everybody was focusing on these issues. So maybe those seconds that young woman by accident, like Gideon, by accident, it happened and she taped it, and everybody around the planet felt that foot on their neck. But this is a reaction to that.
But the focus there was on policing and police brutality and police violence. Do you think the public debate was nuanced enough to also think about trials and prosecutions, about criminal procedure, about public defense for people who can't afford it?
I think it triggered the Floyd incident. It triggered a whole discussion about every inequity you could think of. Look, in the Gideon case, there were other issues there. Speedy trial, fair jury, bail reform. Look how long he sat there, over a pack of beer. But the one that stood out was that one. But look, we have limited attention spans. We're going through a period of less enlightenment. I don't know how long it will last. And it is difficult the easy thing to do is always say it's happening in this building. Boots on the ground. It's hard for somebody to appreciate it, even when they understand it. If the issue was just more of what you have been doing, I think we'd have solved crime by now. The broader issue of guns, by the way, most common denominator in most violent crimes, not all, sometimes it's a knife, but generally it's a gun. So, what you do is give everybody a gun. Everybody get a gun. But you don't want to focus on that because that's politically more of a challenge. But yeah, we're going through a period. It may change. Look, I don't want to, if I might, I want to mention just this one quote, because when I think of that Gideon case, this is Robert Kennedy in '63 as Attorney General, likened Gideon to a demonstration of an individual's power in democracy. Here's his quote: "If an obscure Florida convict named Clarence Gideon had not sat down in prison with a pencil and paper and write a letter to the Supreme Court," the brief was in writing, you got me? "And if the Supreme Court had not taken the trouble to look at the merits in that one crude petition among all the bundles of mail it must receive every day, interns," some intern read that, "the vast machinery of American law would have gone functioning undisturbed. But Gideon did write that letter, and the court did look into his case. He was retried with the help of a competent defense counsel, found not guilty, and released from prison after 2 years of punishment for a crime he did not commit." And here's the last line I love: "And the whole course of legal history has changed. I know a few better examples than that of a democratic principle in action." Powerful words from Robert Kennedy.
Could you imagine a U.S. Attorney General saying that today?
I can imagine one saying it, but I couldn't imagine the Supreme Court reacting as favorably to it as they did the game before us.
Right. It's been a long time since the era of the Warren Court and the long time since the 1960s. One final question.
But brighter days are ahead. I always believe you have to keep hope alive. It's the only thing that keeps us going.
One final question, Commissioner Ellis. Right now, if you were still in the ledge, what are the biggest issues that you would want the state to tackle when it comes to the improvement of indigent defense?
Funding, and go back and look at that bill. There were things that I would have tried to do, but I couldn't do. Just don't give up hope on fairness. At the end of the day, it's all we have that inspires us.
Commissioner Rodney Ellis, thank you for your 40-plus years of public service and for sharing your insights with this panel today. Thank you.
Thank you.